face too.
Biden gave this speech and talked about how, because it was the last year, I think, of Reagan's presidency, we shouldn't do it. But they did do it. I mean, he said it, but no one's ever said that Biden was perfect or that he was the smartest tool in the box. And just because somebody said it doesn't mean, I wish, Republicans pull this out and say, well, that's what Biden said, do. It's the Biden rule. I'm like, but they didn't do it. So it's very convenient for the Republicans to say that, and they're saying, well, we should give the president, the people, the chance to vote. They did vote. They voted for Obama. And what does that say about U.S. representatives? They only have 2-year terms. Does that mean that they're only good for 12 months? And then the second 12 months, we have to wait until the people vote again? Senate terms are now only good for 5 years? It's ridiculous. And it really, really concerns me. We have terrible gridlock in a time when people really aren't getting along, and we have this fear and this hatred of compromise. The fact that we won't even vote, just vote no, okay? But the process is important. It's how our government functions. And when you withhold the process, I think it's very contemptuous of government and of your own position and of the people who elected you. Do your job.
I've heard one of the counter arguments is that they don't want to appear hypocritical because they approved this guy before, and if they disapprove him now, but I thought, when has that concerned the GOP that they vote on something that makes them look hypocritical? So
yeah, when has that ever concerned them?
I'm not too worried about that. So what I want to do is we're going to take a little commercial break, and for the listeners, we're going to come back to the easier cases. We're going to talk about abortion and guns. How's that sound?
Fun.
All right. Hang on, everybody. We're going to do a little commercial break, and we'll be right back.
Here's an excerpt from Nailed by David Fitzgerald.
Didn't there have to have been a Jesus? Perhaps he was just a wandering teacher or an exorcist, an apocalyptic prophet or a zealot who opposed the Romans. Perhaps he was all these things, or even a composite of several such early first-century figures. But at any rate, surely there had to be somebody at the original core of Christianity, arguably the most famous individual in human history. All this seems to be a perfectly reasonable, completely natural assumption to make, so why would anyone be so foolish as to propose that Jesus never existed? Doesn't it just make more sense to assume that there was a historical Jesus, even if we're unable to recover the real facts about his life and death? As it turns out, no. The opposite is true. The closer we look at the evidence for Jesus, the less solid evidence we find, and the more we find suspicious silences and curious resemblances to the pagan and Jewish religious ideas and philosophies that preceded Christianity. And once you begin to parse out the origins of this tradition or that teaching from their various sources, the sweater begins unraveling quickly until it becomes very difficult to buy that there ever was, or even could have been, any historical figure at the center.
Nailed by David Fitzgerald is now available at atheistaudiobooks.com.
All right, everybody. Welcome back. This is Phil Ferguson, and you are still listening to the cleverly titled Phil Ferguson Show. With me is Amanda Knief. And before we get into abortion and guns, Amanda, why don't you give us a rundown of what you do and your involvement in the secular community and your background in law?
Wow, okay. I am the National Legal Director and Public Policy Director for American Atheists, and what I do is try to get myself into as much trouble as possible. I have the privilege of talking to people all over the country who have concerns and complaints about legal issues, and I try to sort through them with these people to figure out what is the best solution for their issues. And sometimes that means referring them to a government agency or telling them they need to get a lawyer. And every once in a while that means that we go to court. We have a case. We try to get the usually government official or agency to be responsive. And if they're not, we end up going to court. And right now we're involved in litigation in Tennessee. And the other half of my job is public policy. And right now, our big issue is the Patients' Right to Know Act, which is legislation that I wrote that tries to bring sunshine to the idea that if you are a healthcare provider of any kind and you restrict patient care based on your religious or philosophical beliefs, you must inform your patients of that. And the way we've done this is that upon patient visitation into your care, you must give them a form that says what services you will not be performing, and they must sign that in an informed consent way. And this is a reaction to the growing number of Catholic health systems and their restrictions on doctor care and the list of ethical and religious directives that they require everyone who works for them to follow. And those ethical and religious directives do not necessarily fall in line with what is right for patient care. And we're not trying to make the hospitals or the healthcare providers provide care that they don't want to religiously, but we do think that patients deserve to know up front that their care is going to be affected by religious directives.
Well, I would like to think, well, in some way, if you're, I'm so upset. I hate the very fact that hospitals can be religious-based in the first place. And I would like to fantasize that this ruling in Mississippi would be in the same kind of thing that can apply as a precedent, that you can't use your religion to deny people services. I understand it's a private hospital, but you're holding yourself out as providing a service to the public. And in many areas, it's the one and only hospital you can go to. So you're denied scientifically based medical treatment because of someone's religion. That offends me.
It is a complicated issue in this country. We have statutes that protect medical providers' rights to deny certain kinds of care to people. You can be a private hospital, but most hospitals depend heavily on government assistance, mostly in the form of Medicare and Medicaid reimbursements, Obamacare. And so what we're finding is that if they were forced to actually provide all the services that patients are entitled to under Medicare and Medicaid, about 20% of the hospitals in this country would not be providing care. And so that's a huge chunk. And so, I'm picking on Catholic hospitals because they are the most obvious and they are the biggest offenders of this kind of issue. They do tend to go to places that are underserved and rural, and so you can appreciate the fact that they're willing to do that, but you can also appreciate the fact that when they do that, those people who are the most likely to be unable to find care elsewhere, have the resources to seek a second option, are the ones that are the most likely to not have all their options then, if that made sense.
Yeah, I'm with you, and you know what? We could probably talk about this for half an hour by itself.
Sorry.
No, I love it, and maybe we need to have you back more often to talk about legal issues. But if I can, let us go to guns and the Supreme Court. What happened there?
So, on the heels of the Orlando shooting and the debate about gun control that we're having, and I hope we continue to have, this is a really interesting decision. It's Voisin, and it's from Maine, and it has to do with the fact that two men were convicted under a misdemeanor assault for reckless conduct. It had to do with domestic violence, and the federal statute right now bans firearm possession for convictions of misdemeanor domestic violence. And so the question was, under Maine law, whether or not these men were entitled to have firearm possession after they were convicted of misdemeanor assault for reckless conduct. And that's what the question was, is how far does the federal statute go? And what happened is you had a 6-2 decision, and they voted to expand it. So now if you are convicted of misdemeanor assault for reckless conduct in its various forms in any state, the federal gun ban will apply to you. And what's interesting about this is you had two justices that don't normally agree on anything dissented together, and that was Sotomayor and Thomas.
Wow.
And Thomas broke his 6 or 8 year silence to ask a question from the bench on this case.
Wait. He talked?
He did. He asked a question about gun rights. This was the first time he'd done that in years. And Sotomayor, her dissent was interesting to me because she talked about the difference between reckless conduct and knowing or intentional conduct. And she felt that by expanding the gun ban, that it was doing a disservice to people who are convicted. That there is a big difference between reckless conduct and intentional or knowing conduct. And that the ban was too harsh. And so that was her dissent.
Now,
Thomas said it entirely.
What is the legal word? How are you using reckless in a legal standpoint? What is the distinction? So in this case, what they're talking about is when you're doing something knowing or intentional, you plan to do it. It was, you meant to hurt someone. There's no doubt that it was your intent. You planned to hurt someone. There's no doubt that that's what was going on. That's what you're being charged with. Reckless can be several different things, but when you charge someone with that, you're giving them the benefit of the doubt that, it might have been heat of the moment. It might have been, in some cases, people might see it as an accident. Maybe you're having an argument and you threw something, or, there's all kinds of ways to interpret it. But what you're doing is under reckless, when you charge someone with that, or when they're convicted, there's a benefit of the doubt that they didn't necessarily intend to hurt someone, but they still did, and it was still enough that they needed to be convicted or charged. And so that's what Sotomayor is saying, is that the majority was saying that, assault is assault is assault. And if you're going to ban it for one, you should ban it for all. And Sotomayor is saying that there are shades of gray, and we shouldn't necessarily do it for all. And it was just a very interesting opinion coming on the heels of this gun control discussion that we're having. Well, it's weird. I often like to make the analogy to cars and guns, because cars can kill people. So under her argument, would someone who accidentally got drunk and ran someone over, should they not lose their driver's license?
I don't think that's fair. I think it's more... I don't think that's exactly what she's saying. And okay. I think that reckless is a lesser and we're talking misdemeanors here, not felonies. And I don't think that that's a fair description. However, Ginsburg and Kagan and Roberts were all on the other side. So again, it was quite a mix of agreement and disagreement that we're not used to seeing.
Yeah, definitely. So does this mean that other states could pass laws that restrict your ability to purchase a gun if you have a certain type of conviction?
Yes.
Okay.
And what it means is it's also good... Yes, it does. And, you have to look and see. I have not had time to see who most often gets this kind of conviction or who's charged with this. But it also means that you get your guns taken away. And that's a really good thing in domestic violence. And so, in so many cases when there's a conviction or someone is charged, this is a really important step for protecting victims of domestic violence.
Yeah, I have a relative that I can't give too many details, and thankfully not anyone too close to me, that had a spouse, we'll just say that the two of them when they got together, they argued, and everyone knew it